All rise.
Please be seated. We're ready for argument in 23-568 Ferchichi versus Whataburger Restaurants and 23-993 Haven at Thorpe Lane versus Pate.
It's the court. Mr. Torgerson and Mr. Poncio will present argument for the petitioners. Petitioners have reserved 6 minutes for rebuttal. Mr. Torgerson will open with the first 12 minutes and will present the rebuttal.
May it please the court. The Texas Citizens Participation Act, or TCPA, was originally passed in 2011 to, on the one hand, protect constitutional rights of persons to petition, associate, and speak freely on matters of public concern without fear of retaliation from lawsuits, while balancing, on the other, the rights of persons to file meritorious lawsuits for demonstrable injury. Importantly, the TCPA was never intended to bar legitimate claims, to immunize against fact discovery, or to insulate bad behavior, including discovery abuse. The very narrow question before this court is whether a motion to compel third-party discovery that happened to include a tangential request for attorney's fees constitutes a legal action under section 27.0016 of the TCPA. The answer is decidedly no. The overwhelming majority of Texas appellate courts that have been presented with this question in Dallas, both appellate courts in Houston, and Beaumont consistently say no. Really, the Austin Third Court of Appeals here consistently says yes, and it's joined sometimes by San Antonio and one or two others. The trend in favor of petitioner's position is clear, and it's become the prevailing wisdom in Texas, and this is especially true after the 2019 amendments. You'll recall that under section 27.005, there is a three-part test to determine whether a case should be dismissed and the burden shifting that associates with that. A movement must show that a legal action is based on or in response to a non-movement's exercise of its right to petition, speech, or association. As a threshold matter, our position on behalf of petitioner is that the TCPA does not apply here for at least three reasons. Number one, a legal action refers to a substantive claim involving a cause of action, not a procedural or an ancillary discovery motion. Second, neither petitioner's motion to compel nor its tangential request for attorney's fees arose from, was based on, or was in response to respondents' communications sought in discovery that occurred back in 2019 and 2020. Instead, the motion to compel was a consequence of the respondent's discovery abuse years after the fact. And thirdly, the respondents in the Third Court of Appeals reasoning leads to absurd results that conflict with the express purpose of the statute in several ways. We'll take each one of those in turn.
Before you talk about the purpose of the statute, just help me understand how asking the court to order the other side to pay you money is not a filing that requests legal, declaratory, or equitable relief.
Because it's not tied to any particular claim, which means a cause of action, like defamation. It's a discovery motion.
Is the sanction some other form of relief that is neither legal, declaratory, nor equitable?
I believe it's specifically a procedural action taken or motion made in an action that does not amend or add a claim for legal or equitable or declaratory relief. And that's in the amendment from 2019 at 27.0016A. And the reason for that is because, as observed by numerous Texas courts of appeals, there is no legal or equitable or declaratory relief associated with a discovery motion, a motion to compel. And the reason for that is because it doesn't stand by itself. It's important, I think, to note there is defined.
It's the sanctions that's the relief, right?
Sanctions.
That is some kind of relief, right?
Certainly. And I will concede that there is a request for relief, but there's relief sought in every motion that's ever filed in a civil court. And for practitioners, we all note that at the end of virtually every pleading or every response, we say, give us X and all other legal or equitable relief that may be entitled to.
And so, as is often the case with the TCPA, we're stuck between the plain language of the statute and the reality of how litigation works.
True, there is a practical divide there. I'll acknowledge that. I will say that if the Third Court of Appeals and the respondents here regard that broadly, that any relief being sought is legal or equitable relief, whether it's in sanctions or order them to do this or make them produce these documents, then it swallows the rule and everything falls under the jurisdiction of the TCPA at that point.
Including a Rule 91A motion to dismiss.
Absolutely, that's a procedural motion. The legislative
Because you
history.
get fees automatically if you win.
100%. In 2019, in the amendments, it's attached as Exhibits 4 and 5, the initial red line of the statute and then the final red line that was adopted into law. And the legislature laid out a number of items that it wanted to include, like a 91A motion. There's a Court of Appeals opinion directly on that, In re Elliott from the Third Court. Importantly, the concurrence in that decision from In re Elliott was by retired Justice Bob Pemberton. And he predicted in the concurrence, I'd get to the same place as you, but I disagree as to how. And the reason is because I predict unintended consequences. This is going to multiply proceedings. We're going to have motions on top of motions, and it's going to delay justice.
Just going back to the language of the exclusion for procedural actions, though, it seems like your point is not so much that a request for fees is not a request for relief, it's that it's not attached to, it's not a claim for legal relief.
Absolutely.
And claim, help us understand what claim means in that context. Is it an entitlement to something?
Well, it does, and that's a great point. If I have a claim for breach of contract, that has elements. Everybody's got O'Connor's causes of actions these days, and it says you have to lay out what the elements of a cause of action for breach of contract are. And in response to that, one of those requirement elements is damages, and that's the relief that I'm seeking. So if I have a contract and somebody owes me $10,000 and they've only paid me $2,000, I say that I'm owed $8,000. I have a legal right to that. When I file a motion for sanctions, I don't have a right to that. This has been acknowledged in the Dane case from the Houston Court of Appeals that is heading your way, as well as in the Thusing case from the Beaumont Court of Appeals. There is no right to sanctions, assuming that's what we even asked for when we asked for attorney's fees. And so there is no legal right that ties to a request for fees essentially as a deterrent or a punishment.
What about temporary injunction?
I think a temporary injunction, there's no question that it's traditionally viewed as equitable relief. Having said that,
Is it a claim or is it
it's a
separate?
procedural vehicle. I would say it's a procedural vehicle. And the reason
It's a remedy.
It's a remedy. If I were to file a petition that says, Judge, give me an injunction, and that's all I said in the petition, and there's no claim for defamation, there's no claim for breach of contract, there's nothing to tie it to. As you know, one of the required elements for a TRO or even an injunction is a likelihood of success on the merits. And you have to look at the cause of action that it's asserted. And it has to have elements. And if you don't meet those, you're not there. And so the statute lays out the procedures, the procedural vehicles, if I can use that term, that the statute contemplates would constitute a legal action. Things like a petition, a complaint, a counterclaim, a cross-claim. None of those are related here. We're dealing with a discovery motion, a motion to compel. That's the vehicle here. That doesn't involve any kind of claim or cause of action. Importantly, remember the purpose of this statute was to avoid retributory lawsuits filed against people who were speaking their minds, generally speaking. There has been no claim
What if the
by Haven.
imposition of the discovery,
I'm sorry?
what if the imposition of the discovery is the retaliatory action? In other words, there's a lawsuit that's ongoing, and somebody speaks out about the lawsuit or about the conduct of one of the parties in the lawsuit, and the next thing you know, they have a subpoena for documents.
That's no more burdensome than any other fact witness that's involved in a case. And the petitioner and any other party in the state of Texas has a right to conduct discovery for anything that's related to a claim or defense. These communications that were sought were tied to the assertions raised by the plaintiffs in the underlying lawsuit, which related to an apartment delay, construction delay, next to Texas State University. And what we're dealing with here is a situation where we asked them for documents. They produced some documents that were cherry-picked. We said, we know you're withholding documents. They said, here's a privilege log asserting what we view to be questionable, if not outright bogus privileges, and said, now give us the rest. You can't partially perform under that discovery motion and then use the TCPA as a sword and a shield. And that's part of our argument here, is that you have to, once you start producing those, there are mechanisms under the rules for a non-party to respond to a subpoena. You can object, you can move to quash, or you can move for protection, or you can just comply and produce the documents. They partially complied, and they objected, but not on the grounds that we're talking about. They never filed a motion to dismiss on the subpoena itself that was served at the end of 2021. They moved instead after we filed the motion to compel in the spring of 22. So they missed a 60-day window, notably. I think this is important. They missed a 60-day window deadline to file a TCPA motion to dismiss as to the subpoena, which they attack, which the Court of Appeals picks up. And there's confusion. What's the legal action here? If you carefully read the appellate decision from the Third Court of Appeals in this case, is the legal action the subpoena? Is it the motion to compel? Or is it the request for fees? There are a lot of cases that say it's not discovery and it's not the subpoena that are published and available. For example, the Dow Jones case out of the Dallas Courts of Appeal.
On that score, can I take you back to the text of the statute and ask
Yes.
you, you are referring to lawsuit cause of action in 270016 here. Petition, complaint, cross-claim, or counterclaim is things that obviously by the text of the statute qualify. So in your view, what does the next phrase capture? That must be doing some work. So in your view, what fits in that bucket? Any other judicial pleading or filing?
So this was raised in a number of appellate decisions, starting by Justice Pemberton in the Third Court of Appeals in Elliott, and then again in Hawkshurst, which they rely heavily on. There's a Latin term that I've forgotten, which says that it has to mean something in that series that's like. And that's the point, is that it has to be a procedural vehicle like a complaint or a cross-claim. That hasn't happened here. They were never sued. The respondents were never sued. They were never third-partied in. They were just simply handed third-party subpoenas and said, give me your documents that relate to the underlying case.
But so can you come up with an example under your theory of what would fall in that?
I think it could be a temporary injunction or a temporary restraining order, so long it is tied to a cause of action that is asserted, that is intended to shut somebody's communications down against the First Amendment. And that didn't happen here.
But even if it fell within that definition, as long as it falls within the exclusion for procedural actions, then the TCPA doesn't apply,
That
right?
is our view, and that we believe that's what is intended. And I'm out of time.
Any other questions? Thank you, Mr. Torgerson. Mr. Poncio, we'll hear from you.
May it please the court. At first, Your Honors, if you would indulge me for a second, I would like to take this moment to honor my prior co-counsel and trial counsel in this matter, Jerry Hernandez, who passed away in August of 2021. With that, we join in the arguments raised by by Haven for Hope Counsel, and I have nothing further to add. Their briefing is excellent in this matter. The only difference in our case was it was strictly a motion to compel, which we claim was not a legal action. While there was an initial motion for sanctions, the record will show that, request for attorney's fees, that sanctions request was dropped. Nevertheless, they brought forward their TCPA action, and we argue it was not a legal action as analyzed in the briefing in the matter, and that as a result, the TCPA doesn't apply. Moreover, the only communication that they raised was they said, we revealed that we had a video deposition, a video of the clients at the mediation, but the crux of the motion to compel was not that communication, but rather the hiding and refusal to turn over the videos that were clearly requested as part of the first 3 requests for productions to the defendants in our case. Simply does not apply.
Any questions? Thank you, Mr. Poncio.
Thank you.
We'll hear from the respondents.
May it please the court, Mr. Dingman and Mrs. Landinger will present argument for the respondents. Mr. Dingman will open with the first 10 minutes.
Good morning, and may it please the court, counsel. My name is Kyle Dingman. This isn't a case about which policy considerations need to be balanced within the TCPA, but rather a case about which branch of government is authorized to do that balancing. To rule in favor of the petitioners, this court would need to do more than depart from the TCPA's text. You would need to take language that the legislature specifically considered and decided not to put into the statute and reinsert it. The petitioner's proposed interpretation that you just heard has two parts. Number one, that a claim has to be substantive. Number two, that it has to be a cause of action. We've got some exhibits that we added, and I'd like to ask the court to look at exhibit number 4 on the first page down at the bottom starting at line 15. Exhibit 4 is the introduced version of HB 2730. That's the 2019 amendments that we're talking about. So this is where the legislature started. And what you can see here is that they specifically looked at, initially, words like substantive relief. They specifically looked at an exclusion for attorney's fees. They specifically looked at an exclusion for motions for sanctions, motions to compel. But then, if we go to tab number 5, again on the first page, same definition. This is the final version of the amendments that were passed. And all of that language that had been considered has been taken out. And so what petitioners
That could mean two things. It could mean it was a conscious intention to exclude those kinds of matters, or it could mean the decision is that the language that's included in the statute these things are fairly subsumed within the language that ultimately was included. So we can't really take anything from that, can we?
I would disagree with that, and I think for two reasons. So number one is that what we care about is the language that they actually passed. What we know is that there weren't 50% of the legislature supporting the word substantive, because if there were, they would have kept that word in. If a majority of the legislature wanted to keep the exclusion for motions to compel, they would have kept that language in. They didn't support that, and so it didn't end up in there. The language that actually got passed, if you just decide this case based on the wording that they actually used, petitioners lose. Because
So
that wording,
If you're right about the interpretation of the language, is a Rule 91A motion to dismiss something that you can file a TCPA motion against?
so I think that really gets down to what is a 91A motion or a TCPA motion.
Well, you
What is it?
automatically get attorney's fees if
You
you
do.
win a 91A motion, so it seems like the consequence of your argument is yes, all 91A motions are filings that request legal relief
So-
and don't fall within the exclusion because they add, in your view, a claim for legal relief.
So I think the important word there is the word request, right? A 91A motion most fundamentally doesn't really request attorney's fees, although that's an incidental form of relief that you might get if you win. You don't even necessarily have to request it. What you're specifically requesting is that a cause of action be dismissed.
Well, here they're requesting documents.
Here they're requesting documents, but they didn't just stop at requesting documents. If you go to the prayer for relief, they specifically say, take the mom's money away from them and give it to us instead. We don't like what they said, either outside of court or inside of court. We're mad about what they said, and so their money should get taken from them, and it should go into our pocket instead of that.
How does that remedy have anything to do with the purpose set forth in 27.002?
How does I'm
The
sorry.
remedy that was requested.
Well, so the purpose of the TCPA is protecting the ability to have speech, to associate things like that.
And how does that remedy that was being requested facilitate that purpose?
Sure. So, we think it doesn't facilitate that purpose. It does the opposite. It discourages that. If people are worried that if they go out and they say things that some big business doesn't like, or just some litigious person doesn't like, and that person's gonna come around and just by labeling their claim a claim for attorney's fees rather than say a claim for defamation or something, they can now keep you in court for 2 years, right? 3 years.
But there is no claim for defamation here. It was a request for documents, and then a dispute ensued about whether the compliance was sufficient under the rules of procedure.
Sure.
Is that the same thing as quieting a party's speech?
So It could conceivably, I don't think this case presents that issue necessarily, but we can, I think that the hypothetical you raised while petitioners were up goes to this. You can't imagine contexts where you get a subpoena that's so onerous that it itself is an attack on speech, but the petitioners didn't stop at asking for documents. They went further and they said, give us their money too. If they hadn't said, give us their money too, we wouldn't be here today. We wouldn't have filed the TCPA motion. It's because what they tried to do was use this subpoena as a vehicle. And if you look at the motion they actually filed.
But the question has to do with the remedy that was requested really doesn't have anything to do with the purpose set forth in the statute. And so what are we supposed to do with that?
I think the purpose of the statute is ensuring that people have the ability to speak. The question then is, can you use a request for attorney's fees to stop people from speaking? Can you shut people up? Can you intimidate people with that? And a request for attorney's fees has the same effect ultimately on an ordinary person as a request for any other form of damages. It's not like you get to pay a request for attorney's fees in procedural dollars. You still get.
Are you arguing that it makes any difference that this pleading, what they filed against you, brought your clients into the litigation?
So, do you mean as parties?
This is what drew you into litigation between other parties, right? So you were brought into court by what they filed. Does that make a difference?
Yeah, I think that does make a difference because
Even though you didn't file the TCPA motion against the subpoena that brought them into court?
well, the subpoena doesn't fit the definition of a legal action because the subpoena isn't a judicial pleading or filing. It's not a petition. It's not a counterclaim. What is a judicial pleading or filing is the motion. And so the motion is the legal
motion
action.
was after you were already in court.
We weren't in court the mothers had never filed anything in court until the motion to compel was filed. So the first time the mothers file something in court, somebody has already filed something against them saying, we want to take away their money, we want it for ourselves because we don't like what they said. That's why the TCPA applies here.
Is that why, or is it because it's an effort to recoup the expense of having to adjudicate this ancillary dispute about whether the subpoena was fully complied with? And if you fully complied with the subpoena, then presumably they can't get attorney's fees. And if you didn't, then is it really to have anything to do with speech, but really more to allow them to recoup expenses they undertook because of the failure to comply with the subpoena?
So I think a couple points on this. Point number one is that there is no mechanism, and there has never been this entire time, this entire 3 years they've been chasing the mom's money, a mechanism that allows them to take money from third parties. There's fee shifting when it comes to discovery disputes between parties, but there's no such thing when it comes to discovery disputes involving third parties, and so it can't be that. This fee request is there essentially as a naked demand for, we want their money. And the second point is that our position, there's obviously a dispute between the parties with respect to the facts, but our position is that this subpoena, when you look at how it's drafted, it has all sorts of ridiculous requests in there that are obviously intended to essentially pick a fight, to give them a vehicle to come in and harass the moms. Because these moms, when you look at them, really ruined their lives for about 1.5 years. And so we don't look at this as, oh, this is just discovery. Lots of the stuff that they ask for has nothing to do with this case. It's just anything to do with, like, for example, which attorneys they recommended or something like that, right? That's not anything to do with the merits of the case or with anybody's damages. That's just something that they're asking for to pick a fight so then ultimately they can come and make this frivolous monetary request.
Let me take you back to the language of the exclusion. A procedural action taken or motion made in an action that does not amend or add a claim for legal, equitable, or declaratory relief. So this is obviously a procedural action.
Yes.
And the question then is, does it amend or add a claim for legal relief, the attorney's fees? So in what sense is this a claim?
So
I understand that attorney's fees could be considered legal relief, but I think the key word there is claim. And if you look at what we said in Montelongo, we're looking at, are there new factual allegations or something like that? And here it seems like there are no new non-procedural factual allegations that are involved.
So this is definitely something that we want to ask the court to look at. Exhibit number 1, this is their motion. The first 15 pages of this, it doesn't read like a motion to compel. It reads like a defamation action. It is entirely about how the mom said stuff they don't like. That's the new facts. That's the new parties. That's the standard from Montelongo. But you have a better definition of claim, and that comes from Johnson v. Higgins. And that definition is a demand for compensation or an assertion of a right to be paid. That's the most natural reading of the statute here. That's what matches.
So what's the right to be, they don't have a right to be paid, do they? This is totally within the court's discretion. It's not like a claim for damages.
So if the court were to adopt a rule that says anytime you don't actually have the right, like your claim is ultimately invalid for some reason or another, so therefore it falls outside the TCPA, you're going to essentially create a system in which the more frivolous a claim is, the less defenses actually exist against it.
I understand your concern about that, but that's not what I'm suggesting. What I'm suggesting is that if you win, you have a right to it, and the court has no discretion not to give it to you is one thing. But here, even if the court thinks that the party is right and they get all these documents, it could, in its discretion, decline to award attorney's fees. So in that circumstance, in what circumstance do you have a right?
And in fact, it has no discretion here. The court cannot award attorney's fees. Like, there is no mechanism for the court to award attorney's fees in the context of a third-party subpoena. The court doesn't have discretion over that. But, again, I think this goes to the real matter is, are they asserting a right? Are they saying, give this to us? Are they making a demand? Well, they clearly are. That actual, I think, natural interpretation, the way that these things, because we don't say that people only have a claim for attorney's fees when they ultimately win attorney's fees. People have a claim for attorney's fees when they're asking for attorney's fees. That's what makes you have a claim for attorney's fees.
Any other questions?
Can I just make sure I understand, if the claim for the fees, the demand for money is the thing that's doing it, if someone were to file the same thing, all the stuff about what they'd said and everything, say, we don't want any money, we want them to go to jail until they comply, that's not something that,
so that
different things, one's a legal action and one is not?
Yeah, I think that's neither legal nor equitable nor declaratory, and there's actually a case, I can't remember it off the top of my head, but we cite to it, where the Houston Court of Appeals considered whether the contempt remedy was something that fell within the TCPA, and they held that it wasn't. I apologize, I don't have it off.
If somebody really just wanted to mess up somebody else's ability to participate, just avoid ask for money, no TCPA.
Yeah, that is something that I think is just a good piece of advice, and that's really, if you're not ready to satisfy the prima facie component of your claim, don't ask for money, because you're going to be vulnerable to the TCPA.
Any other questions? Thank you, Mr. Dingman.
Thank you.
Ms. Landinger, we'll hear from you.
May it please the court. Counsel. In my time before you, I'd like to address 3 points. First, and probably the most importantly, Whataburger did not file a motion to dismiss, a motion to compel discovery. This is established by page 136 of the record. Second, motions for sanctions can only be excluded from the definition of a legal action by adding words and phrases to the statute that the legislature did not. And third, excluding sanctions motions from the definition of a legal action would defeat the intended purpose of the act, which is to protect certain constitutional rights from attack.
So is a TCPA motion itself something that is subject to a TCPA motion?
Absolutely not. Because it would not add a claim for relief.
Well, they're asking, that
Get attorney's fees.
sanctions.
Right. So a TCPA motion, when the TCPA is invoked, it provides for attorney's fees for both sides. So adding a second TCPA motion on top of it would not add another claim for relief. And it would also would defeat the purpose of the act. And I think that that's something very important. We always have to go back to what is the purpose of the act. And the purpose of the TCPA is a summary dismissal of these attacks. And of course, every time you file a TCPA motion, there's kind of this stop in the proceeding. So if you file one and then another and another, the timelines would stop indefinitely, right? That would defeat the purpose of the
But
act.
isn't that exactly what happened here? Because there was a failed mediation, and then a dispute arose about the mediation, and there was a request for sanctions based on what happened in the mediation, not conduct, not pre-suit conduct, and then the whole lawsuit stopped because of the TCPA motion.
Well, the TCPA motion petition, Whataburger has been put in a position, if it did not have the TCPA motion, the only way it could defend itself against these allegations is to put a mediator on the stand. And I think and I'd like to clarify exactly what this case is about because it informs everything else that follows.
No, there is something short of the mediator on the stand, right? You could say they're not entitled to that discovery about what happened in the mediation or to sanctions because everything that happens within a mediation is confidential and protected from discovery. Therefore, motion denied, sanctions denied, case continues.
But without the TCPA, and again, this goes back, if I could, I'd like to go to my first point. Whataburger, when it moved to the TCPA motion filed by Whataburger, did not move to dismiss anything related to discovery at all. The only thing it moved to dismiss are these claims based on allegations of what it allegedly told a mediator. And part of the problem is it's been coupled in, there's these false allegations of discovery abuse. And that's been coupled in with these allegations of these things that Whataburger allegedly said. And so there is no way for Whataburger to move forward in the case without addressing these. Petitioners are asking Whataburger to prove a negative, to do something impossible. And without the TCPA being applied to that, Youngkin. In Youngkin, this court said that the TCPA, the purpose of the TCPA is to prevent parties and their counsel from being silenced. Now, if Whataburger has to fear what it says to that it can have sanctions brought against it for what it says to the mediator, it's fearing.
I think the toughest point for you textually is this word claim. And the statute refers to cross claims and counter claims, and we wouldn't normally talk about, this kind of a discovery motion as a cross claim or a counter claim, but your position has to be that it is nevertheless a claim. Why would we interpret the word claim to include all of these things that are very different from cross claims and counter claims and petitions and complaints?
Well, first of all, it's not very different. If we look at how the statute was written, if the legislature intended to just exclude all procedural motions from the definition of the TCPA, it could have just stopped there. These, procedural motions are excluded, period. It didn't do that. It added in tail. It said, that do not add or amend these, claims for relief.
Right, but then we have the exclusion for procedural actions that don't amend or add a claim. So that's where we get to the definition of claim.
Right.
And we talked about that in Montalongo. And I guess my question is why would this be a claim under Montalongo? Because you don't have any new parties and you don't have any new non-procedural factual allegations. So it seems like this is not a new claim.
It actually is. And that's, going back to my first point. The motion that was filed by petitioners, it had two parts to it. It involved things that the mediator allegedly told them.
So that's procedural.
Okay. And then it had the things that Whataburger allegedly told the mediator. And the motion is based on these five, six affirmative statements. And they accuse Whataburger of manipulating. Petitioner's counsel accuses Whataburger of manipulating counsel, of trying to direct the course of the proceedings. Those allegations have nothing at all to do with the facts of this case.
And exactly, they just have to do with the procedure. And so that's why I'm struggling to see why this is a new claim under that exclusion.
Because the allegation that Whataburger's counsel said and did all of these things, that has nothing to do, that is unrelated to the merits of the underlying allegation. Petitioners are asking for money. They're asking to be compensated in a tort case based on the allegation that Whataburger's counsel allegedly said something to a mediator that constituted manipulation. That's involving, Whataburger's counsel isn't a party to this case. This is accusing somebody else of doing something. And whether or not there was manipulation, that has nothing to do with the underlying case. I would say, following Montelongo, it does add a new claim. It's completely unrelated to the merits of the case. And that's, I think, something important. When you look at the motion to dismiss that was filed by Whataburger, they did not move to dismiss anything related to discovery. Nothing at all. And that's, in fact, they didn't even move to dismiss the parts of petitioner's motion where they sought things referenced by the mediator that weren't subject to discovery. The only thing Whataburger sought to dismiss is this attack, these claims of manipulation. And unfortunately, I'm almost already out of time, and I want to make two very brief points. And I think this is important. The legislature could have stopped if it wanted to exclude procedural motions from the definition of a legal action. It could have just said procedural motions, but it didn't. And if we ask, the legislature recognized there must be some procedural motion that falls within the act. And a motion for monetary sanctions, it does a lot of things. It can survive a non-suit. It can be compensatory. It can be punitive in nature. And if the legislature is not referring to a motion for sanctions, what is the legislature referring to? Hawkshurst was decided 1 year before the legislature told us very clearly what it intended to include and exclude. And this exclusionary language tracks Hawkshurst. Of course, in Hawkshurst, the court said, it doesn't matter if you're bringing your attack in the form of a petition or in the form of a motion for sanctions. An attack on a protected right is an attack on a protected right. 1 year later, the legislature added this language. It said, we're going to clear this up. We're going to tell you exactly what we want to include and exclude. And it did not say, we want to exclude all procedural motions. We believe the legislature was addressing the fact that parties can creatively plead around the TCPA, and that's exactly what the legislature was trying to prevent.
Any other questions? Thank you, Ms. Landinger.
Thank you.
Mr. Torgerson, you have 6 minutes.
I'd like to pick up on a few of the comments and questions from the justices, as well as some of the comments from Mr. Dingman, as well as to wrap things up here today. The role of the judiciary is to interpret the legislature. There is no displacement going on. From a separation of power standpoint, I think we're exactly where we need to be, especially given the case law coming from, especially from the Third Court of Appeals. I believe, Justice Bland, you're right that the intent here, there's different ways to read the red line between Exhibit 4 and Respondent's Exhibit 5 of what actually was passed. And the reason is it included specifically a motion to dismiss a legal action, a TCPA motion to dismiss. This was raised by another justice. That's the Paulson versus Yarrow case. It seems to me that somebody in the legislature sat down and read these opinions from the various courts of appeals and said, let's include language that says you can't do this and you can't file a motion to dismiss in this context or that context, or that context. And instead what they said is, these are fairly subsumed in higher level language that could address more flexible other types of factual or procedural circumstances by just calling it procedural. And we think that's exactly what happened. You have to harmonize the entire statute. One point I want to make, what's the sole remedy under the TCPA in filing a motion to dismiss? To dismiss the case. How can you dismiss a subpoena? You can't. You can only quash it. How can you dismiss a motion to compel? You can't. You have to deny it. They're trying to put a square peg into a round hole, and they're playing semantic games, again, that do not comport with the statute, do not comport with the intent, and plenty of other courts of appeals across Texas have noticed
You say that
this.
it doesn't comport with the intent, but you've tried to bring in non-parties who were criticizing you and impose very onerous litigation burdens on them. They were not parties to the case before you did that. And it seems to me you ought to be arguing the text of the statute, because the intent of the statute seems to me to stop exactly the kind of litigation tactic that you use. Now, whether or not the statute covers the specific thing you did textually is a separate question.
I would say, I understand where you're coming from. Respectfully, I would say we were subpoenaing them because in the first instance, they were key fact witnesses. They were in everybody's disclosures. They were involved. They were in the press. There's no question about that. They're also the mothers of 2 of the 40-odd plaintiffs in the case. What we also know is that we had to go to them for documents, and this is in the briefing, because their children, adult children, had spoliated evidence. They had destroyed texts, they had replaced phones, they had not backed up data. We needed to get this information from another source. They didn't object on these grounds under the TCPA when we sent those requests to the plaintiffs.
That may very well be true. I don't think it matters to the resolution of this.
Sure.
But my point is just that you've got people who are not in the case, who are publicly criticizing you. You bring them into the case and impose litigation burdens on them. You've got to acknowledge that kind of a situation seems to be what the TCPA is aimed at.
I think there are other rules of procedure that address burden, specifically as to non-parties under Rule 76. And that was not raised at the time, that this is too burdensome or that this is costing too much. They never raised this. They never filed a motion to quash. They objected, but they never did anything on that basis in the subpoenas that are in the record. And they certainly never sought protection from the court. There are other rules that they could have gone to instead of going to the TCPA motion to dismiss, which again, they weren't subpoenaed because of their communications. They were subpoenaed for other reasons that I've just explained. The other issue here.
But did that subpoena seek discovery into their communications?
It did, absolutely. We concede that point, there's no doubt. And the reason is because it ties to the allegations that the plaintiffs had asserted. One of the major allegations is what's the cause of the construction delay? And we believe that there was misinformation being spread. By a variety of different people, not just these 2 individuals. And we were seeking that. We had already sought through Open Records Acts communications with the city of San Marcos. It says in the briefing, we don't think we got all of that either. And we're trying to get a full record here so that we can defend our client in the underlying suit.
Well, but the underlying claim is it didn't open in time for school to start.
Well, that's on the merits.
Not misinformation, not something on the internet. Were the dorms open or were they closed?
Absolutely. And,
Right.
and we don't, we
And was
concede
there
that.
a promise or a representation made that they would be ready on time?
Absolutely. And respectfully, from our perspective, we're willing and able to deal with that before a jury in Hays County at the appropriate time. The narrow issue here is this a legal claim and what can we do about it? It seems to us that, the Misko versus Johns case in the TCPA very clearly says that discovery abuse is not a protected right. That's not free speech. And more importantly, in Justice Baker's dissent in the Third Court of Appeals on this case, at page 490, he said, quote, Haven's motion is based on and is in direct response to the non-party mother's alleged violations of discovery rules, not anything else, and quote, certainly not from TCPA protected conduct. At the end of the day, we ask this court to overrule the Third Court of Appeals, to remand the case back to Hays County, and so that this case can move forward. We have been delayed over 2.5 years, and we look forward for the case going. We do not believe this is a legal claim.
Any other questions? Thank you, Mr. Torgerson. The case is submitted, and the court will take another brief recess.
All rise.